Greetings, my name is RAISSA and today I'm here with my friends Mikea, Lawrence and Ken. We are going to present our presentation about the sources of law. Enjoy!
My name is Ramalina and Manitra, and I'm going to present the meaning of the term sources of law, which differs from writer to writer. Concept. The positivists use the term to denote the sovereign of the state makes and enforces the law. On the other hand, the historical school uses the term to refer to the origin of law, but also other uses it to indicate the causes or subject matter of law. According to Prof. Fuller, in his Anatomy of Law, states that a judge interprets and applies certain rules to decide upon a case. Such rules are obtained from various places, which are known as sources. He further goes on to give examples on the common sources of law, such as codified laws, judicial precedents, customs, juristic writings, expert opinions, morality, and equity. According to Holland, he has defined the term to mean the sources of the knowledge regarding law. However, KLN defined the sources of law as agencies through which the rules of conduct acquire the character of law by becoming definite, uniform, and compulsory. Oppenheim defined the term sources of law for a historical fact out of which the rules of conduct name into existence and acquire legal force. And Keaton defined the term sources of law as the material out of which is eventually fashioned through the activity of judges. And finally, John Austin has 3 points in his definition of sources of law. The first one is the immediate or direct author of the law. The second one, the historical document through which the body of law can be known, and the last one, the causes which have brought into existence the rules which later on acquire the legal force.
Material sources. According to Salmon, material sources are the source from which the law derives the matter of which it is composed and not their validity. Material sources could be subdivided into 1. Legal sources. Legal sources of law are authoritative in nature and origin, and followed by the court as a matter of right. They are the instrument which creates legal rules. They are the gates through which new principles find their admittance in the legal sphere. Legal sources are legislation. Legislation, according to Salmon, is the source of law which consists in the declaration of legal rules by a competent authority. Precedent. According to Keaton, judicial precedent as a judicial decision with some amount of authority attached to it. Its function is to fill the gap with the new law. Custom. According to Salmon, custom as an embodiment of principle of justice which have appealed to the national conscience. Agreement. Treaties and convention are written agreement that states willingly sign and ratify and as such are obliged to follow. Professional opinion. Professional opinion is an opinion of leading jurists who have influence on the judgment of judges in making decisions. And second is historical sources. Historical sources are originally found in an unauthoritative form and are subsequently admitted and converted into legal principles. They are operated indirectly and mediately. Historical sources may become legal by recognition by law, as such, or incorporation in law. Historical sources include foreign decisions, juristic writings, and other things a judge derived while giving his judgment.
Formal sources are those sources from which the law derives its force and validity. That is, the will of the state, which is expressed through statutes and judicial decisions. Formal sources of law includes the will of the state, will of the people, and the judicial decisions of the court.
If you like watching our video, please leave a comment and like the video. Thank you. See you next time.